course, and I'm not going to start with the introduction that CSIR has been in the forefront and all those things. I leave that to Dr. Sanjay Kumar, who had been our representative in the National Biodiversity Authority for years together till he superannuated from CSIR. So he'll come up and of course, I'm sure he's going to elaborate on many case studies, the way CSIR has taken this forward. But the reason why we are celebrating the biodiversity, across the country, across the globe every year is our way of acknowledging what nature and its natural resources have done for mankind. And also to build in more awareness on the conservation of this nature and natural resources. It is very easy to exploit, the natural resources and do all kinds of things. We are seeing that kind of, maybe some of the impacts also when there is over exploitation. But it's very important that we do take cognizance of this fact that nature and natural resources are to be conserved. Not only that, all those people who have been over generations conserving and sustainably using natural resources, their efforts are also to be acknowledged. And by celebrating the National Biodiversity Day or National Biodiversity Week, or even celebrating biodiversity every day in our lives, it's very important to acknowledge and to appreciate the efforts that have gone in, by people across the globe in conserving and also sustainably using biodiversity. We have in India, there are many, I think we have the largest number of biodiversity hotspots in our country. And each hotspot is, I would say, just a maze of what all nature can offer. It is only, however, number of times we go to certain regions, there are surprises in store every time. So that is what, nature brings on the platter for all of us. It is for us to use it sustainably. And of course, the National Biodiversity Authority is doing a tremendous job in trying, towards the sustainable use of biodiversity, who are conserving nature and natural resources and sustainably using them throughout for commercial exploitation. I won't speak much more about it because there are experts lined up who are going to talk about it. So without coming in between them and all of you, let me just introduce the first speaker, Dr. Sanjay Kumar. As I said, he's presently the chairman of ASRB, the Agricultural Scientist Recruitment Board. But before that, and I think he still is a CSIR person. He's our person there, sitting there. Dr. Sanjay was the director of IHBT, Palampur. And he, I think, started his scientific career from IHBT itself and climbed up to the ladder, topmost ladder of the director. And he's led IHBT from the front. So, and of course, as I said earlier, he's been our representative in the National Biodiversity Authority for years together. I think till he superannuated, he was the CSIR representative there. So with this brief introduction, Dr. Sanjay, I'll leave the podium to you. The floor is yours. Please do make best use of it, and a request to all those who are attending this webinar. Please do ask Dr. Sanjay and the other experts any questions, any reservations that you have related to biodiversity and the biodiversity rules. So thank you all very much. And it's over to you, Dr. Sanjay Kumar.
All right. So thank you so much, Dr. Vibha, for this generous introduction. And let me greet all of you on this very important event. I won't say day because day has already passed. So I would say that it's a very important event that you are organizing on International Biodiversity Day. Normally it is on 22nd, but we are organizing it today. I thought that I would like to share some of my views and try to give some new dimensions. And as we know that this year, this IBD is about uh, harmony with nature and sustainable development. Therefore, the word development is very important and harmony with nature is very important. So I thought, why don't we talk a little bit on the bioeconomy aspect of biodiversity? At the same time, we try to sustain our environment and the whole scenario. Um, and let me also just very quickly remind that when we are celebrating this International Day of Biodiversity, you will all agree that this year it seeks to focus and it seeks the world attention on the linkage on two important issues. One is the 2030 agenda and its sustainable development goal, and second is the target of KMGBF. You are all aware this coming Montreal Global Biodiversity Framework, and there is an appeal that these two universal agenda, they must be pursued in tandem. I'm sure that when I was seeing the program, I realized that there are several experts who would be probably talking on this important issue. To this gathering, I need not to highlight the importance of biodiversity, but I think it's still important that we should remember that so far around 1.75 million species they have been identified, and there are estimate that there could be approximately, the range is very high, let me tell you, 3 to 100 million species probably it might be existing. So when we talk of biodiversity, we talk of all the variety of life on our planet. We talk in terms of species diversity, we talk in terms of genetic diversity, we talk in terms of ecosystem diversity, and also we should not forget that we should talk in terms of agro biodiversity now, because this agro biodiversity for sustenance of our human society is so important, whether we talk of wild relative species of the crops, whether we talk of domesticated species, whether we talk of animal genomic resources, whether we talk of various services, for example, pollination services, water conservation, maintenance of soil health, climate change mitigation. I think here our agro biodiversity is going to play a very, very significant role. We should not forget about it. I must also mention that when we talk of agrobiodiversity, food security is very critical aspect of biodiversity. You all will agree with me, if you see the three major crops on this earth are maize, wheat, and rice, which sustains 40% of the world's plant-based calories. You will all agree. Although we have approximately 7,000 plant species cultivated for food, but only 170 are cultivated commercially. And out of that, merely 30 of them provide the majority of our daily nutrition needs. So that is the scenario. And therefore, we have to start from here and we have to start our journey from here. And when we see, very recently I was going through some of the data on this UNDP, and it was alarming situation that our wildlife population, it has gone down by 73% in the last 5 decades. And I think it was something very significant if we are coming to that sort of level. Therefore, we all have our collective responsibility that we take it forward. And uh, today, biodiversity, why when we say that there is loss of around 73%, it is because that we have unchecked exploitation of natural resources. Our population growth is there. And also there are invasive species. Deforestation is a major problem. And certainly and climate change. So they are making all these our biodiversity, and because of them, biodiversity is under a lot of threat, and we should be aware of that. Now, thing is that as a scientist, what do we do? And biodiversity, if you see our life, it adds a lot of value. You might remember, in 1995, I remember once I was coming along with Dr. Mashelkar Saab. He was our honorable DG at that time. And he was telling his story that how he fought the turmeric patent, which is popularly known as Haldi Ghati ki Ladai. It was all our knowledge, our biodiversity knowledge. We added value to our biodiversity, but foreigners wanted to claim. But then Indians, they fought and they won. And the CSIR had played a very, very significant role. And when I heard that story, I felt myself so elated that I am associated with an organization known as CSIR, which works for the benefit of its nation and to protect its rights. And that was very, very significant. Anybody wants, I think in current science, very nicely written article is there, and one should certainly go through that. Another, I think 2 years later, again, there was fight over Basmati. And at the time, ICAR and CSIR, both of them fought together. And again, an example that, biodiversity has so much value that internationally people start fighting and want to utilize that. And therefore, we and our role become very, very important, that how we protect it, how we value it, and how we take forward. And therefore, our scientific community, they have a lot of responsibility along with the local communities, because this is one area where scientists sitting in the lab cannot function. They have to be in connect with the society. They have to be in connect with the community, and we should not forget that. Even school children, they should be part of it. And this is the time now. And the way science is progressing and growing, I must certainly urge all of you that try to adopt the frontier technologies as far as biodiversity assessment and conservation is concerned. I feel when we talk of biodiversity, there are several issues which are important. First is we should assess it, right? We should know that what are the resources available with us. Then we should also know where are they located. We should also know what is the quantity in which they are located. And we should also know what is their current status. And their status is how is changing over a period of time. So the technologies like classical way of going and surveying, using the remote sensing technologies, using the drone-based technologies, I think we should deploy all of them and move forward in this direction. I remember long back when I was director at IFT, equipped actually our remote sensing lab. So a lot of hyperspectral data, multispectral data, visible near infrared spectroscopy, all those things we had included. And by that, we were able to differentiate, for example, various forest species, age of the plant, and a variety of the things we had done using these technologies. And it laid the baseline data of the plant biodiversity, at least in our region. And now is the time that we move beyond plant diversity, because here we are talking of biodiversity, our insect diversity, animal diversity, fish diversity, all diversity. It's time that we try to make a proper database and try to address those 4 issues which I mentioned 2 minutes back. Now, apart from understanding what we have, we should also think that how we add value to that, right? Ultimately, if we don't add value to our biodiversity in a sustainable manner, what should be our reason to conserve that biodiversity? Not only for our sustenance, but I think there should be some financial aspect of that as well. When we talk of financial aspect, there is a concept known as bioeconomy. And if you see today's bioeconomy status, I think our bioeconomy, what I was reading very recently, is around 155 billion US dollars. And it is around 4.25% of India's GDP, right? And our target is that by 2030, we have to be 300 billion US dollar. And it is something very significant, although very easily achievable as well, provided we all get together and act in that direction. When I say bioeconomy, what could be various components? I was just thinking where biodiversity could add value. For example, you see this biofuels, your bioplastics, your enzymatic applications, in things like BT cotton, precision agriculture, they can all add value to this bioeconomy. Although the list is very long, for example, all biopharmaceuticals, they will be very important component in times to come. Um, but when we say that bioeconomy, then value chain is very key component. If we don't think of value chain, then what will happen is our bioeconomy will be non-sustainable. For example, important thing is that there should be raw material. Normally, we overexploit, we should avoid overexploitation. Then, if our raw material is in abundance, we should ensure that then we have a range of product that we should think what new product we should develop. We should establish our market linkage. We should make it available to the consumers. And one very important component, at times we forget that as an institution, if we give a know-how to someone, we should also try to handhold if they fall into some trouble. For example, if there is, when you buy some equipment, it goes back, then you go for the service part, right? So as an institution, we had a responsive support system very extensively so that our entrepreneurs who take any technology from us, they are sustainable, right? And as I mentioned, in this value chain, the first important thing, that is raw material, that is very important. And even in raw material, we should not forget to include the latest technologies, right? And we should try to see what new technologies we can take over. I give you few examples. You know, we were, when I was at ISBT, in a crop known as Picoryza curva, and that plant is considered as endangered plant species. And as a biotechnologist, as a scientist, we thought that what can we do about it? At that time, you know, we had a very good group of tissue culturists. Dr. Anil Sood was there, Dr. Amita Bhattacharya was there, Dr. Ahuja himself was there, and they all gathered together and they developed a micropropagation technology. And they, you know, interesting part was not only it was developed within the lab, but they took out the plant to the field. You see, such a significant thing, from lab to land to lab, and lab to land. And the persons who were collectors at one time, they suddenly became the cultivators. So we changed the whole status. And at the same time, we conserve our biodiversity, right? So that is the power of science which can be done. And we did only, not only for Picoryza curva, but range of other plant species as well. Like, for example, fritillaria, you know, this is one of the Astuvarga plant species. We did with that. Podophyllum hexandrum, we did with that, right? So whole range of tissue culture raised plant species were taken to the field. And that is a very significant aspect of marrying the biodiversity and high-end technology. I'll give you. And you can see that, you know, how we also empower our country. For example, you know, in Himachal Pradesh, if you go and visit various fields, you will find several mountains, there is hardly any vegetation. We went to the farmers, we asked them, what is the reason why your land is not being cultivated? They said, sir, there is a lot of risk of wild animals, and because of that, we are not able to take it forward. Then our scientists, you know, we have Dr. R.K. Sood, Dr. Rakesh Rana, Dr. Sanat Sujat at that time, and they all gathered together. And at one time, Dr. R.P. Sood had brought in this Tagetes minute owl, wild marigold. And it was, you'll be surprised, this is one of the plant species which is so prevalent in Himachal Pradesh. But our institute, what they did, they developed a right variety of that. And then at that same time, we had enormous support from CSIR. CSIR said, let us go to the field, let us see, try to solve the people's problem. And then we said, why don't we empower our communities through right varieties, through processing technologies, establishing a value chain, and at the same time, we protect our environment. Because that land was just open. So during rains, all the minerals will go away. So we wanted to protect our environment as well. So we started cultivation of wild marigold, which was a natural planting species of that area. Only thing, as a scientist, we had improved the variety. We gave them processing technologies. We ensured the quality of the oil which was being produced, and as a result of which, in 4 years' time, Himachal Pradesh became the biggest producer of wild marigold essential oil. And let me remind you that this marigold oil used to come from South Africa, and now around 7 to 8 ton was being produced in Himachal Pradesh itself. So very significant move. In it empowered our communities, it protected our environment, right? We developed lot of products, so that aroma based products, so that startups were supported, and it did a lot of livelihood upliftment scenarios in the region, and added a lot of value. Another point I also wanted to mention, it's not only aroma, you know it's floriculture, for example, that also served to empower our people, and to empower our and to protect our environment, particularly in cold desert areas. They came under cultivation once we started tulip cultivation. And in 2022, Himachal Pradesh first tulip gardens using the bulb produced in India, it was established, right? So bulb produced in India was very significant. And I was very happy to see, in 22nd January 2024 newspaper, they said that the flower of tulip were offered to Ramlala using the technologies of CSIR. And it gives you so much value moment you listen the name of your organization. Then in 30th December 2024 publication in Hindustan Times, when they were celebrating the ninth tulip festival, there they said that around 15,000 indigenized bulb were supplied by CSR ISBT. So once you see the name of your organization, it elevates you, right? You will all agree with me. And like that, we had done a lot of product formulation, lot of product generation, and all those things we had done. Now, one important thing I would like to mention, in India today, we take for granted that apples, peaches, apricot, maize, almond, sweet potato, garlic, chili pepper, onion, lentil, tomato, pears. You will all be surprised. Maybe some of you may be knowing, but all these crops were introduced in India by Spanish, by Mughals, by British, and by Portuguese, right? We did not have these species in India. But today is the time that whenever we introduce any species in India, it has to be with caution. For example, you have an agency like National Bureau of Plant Genetic Resources. They have quarantine methods. So unless you quarantine, please ensure and spread that message that such species should not be introduced in India. Although species introduction is very important to make self-reliance India. Just to give you an example, hing we introduced in India in 20. Initially, actually, we had started this activity in 2016, and we initiated this activity in 2016. In 2020, we did the first sowing, and 2025 we got the first seed produced. I was very happy to see Dr. Vibha. Yesterday, I saw at our CSI website that a major milestone was achieved when the hing showed flowering and seed production. So grateful to CSIR that they recognize the effort. And this effort we started in 2016, remember? And it took us 10 years before you see the fruit of our effort. So sometimes it takes that much time. But the organization like CSIR, they have that patience and time, and they allow it also because they are knowing that if you have to make a India, if you have to make a powerful India, I think you need to invest time and energy. So, madam, my compliments to you and our DG madam that seeing that post was a very proud moment for me. At that time, you might recall Dr. Bislal, Dr. Ashok Yadav, Dr. Sanat Sujat. So we all got together to get these seats. And today, and very important, we should not forget the contribution of state government. We should not forget the commitment of our farmers. We all were together. State agriculture department, and therefore, when we could see this fruit what we are from harvesting today. Similarly, madam, we did for a lot of efforts in saffron. When we try to empower our nation, we thought that what nation is dependent on how many issues, and we realized that saffron is imported in this country to a tune of around 90 tons, right? Even in northeast part of the country, apples are imported from Burma and other places, right? And we thought that why don't we empower them? We empowered them. And even Honorable Prime Minister, he mentioned once about this apple in northeastern part, right? You might recall. And for he, Honorable Prime Minister also mentioned, I think, in our society meeting. So such things not only give us confidence, but I think empowers our nation, and that is important for us. I was also very happy to see, the last few months that Mr. Ravinder Sharma from this Agri Naturals India, it opened a system, or sorry, it established a complete plant, stevia processing plant. I was very happy to see that. He was associated with our institute for the last, I think, 10 years or so. So, and stevia, everybody wants on stevia based product. So I was so happy that consistency our CSR permits for people to adopt the technologies. At times it takes time. So right from cultivation to processing, our Ravinder Sharma took 10 years, but finally he succeeded. And I think that matters. Similarly, madam, just wanted to share with the other audience also, India still needs so many other crops to empower. For example, monk fruit. It's only produced in China and then processed in US and New Zealand and then supplied throughout the world. Why not India also participates? So ISBT had introduced this monk fruit. I think only time to amplify that. Similarly, when we talk of agro biodiversity, I was surprised, as a student, we used to read that Kerala is the center of origin for dalchini or the cinnamon. But I was surprised to see the export data. Around 45,000 tons of cinnamon is imported in this country. So our scientists, they had introduced the cinnamon in Himachal Pradesh for the first time. I thought similarly mulati, during COVID time, everybody had throat infection. They wanted mulati or licorice. And we realized that we all get it from Afghanistan. So we had initiated some work on mulati as well. Then one point I would like to emphasize that when we talk of biodiversity and value addition, and in the value chain, apart from raw material, when we go to the final product, validation, scientific validation of that final product is equally. For example, we had developed some formulation to protect the cartilage health. And to protect that health, then we had validated it through some medical college and human trials were conducted. Similarly, our malnutrition program, we had developed range of products, but then it was all validated. So I think these are some of the things I wanted to share. And in the last, I would like to add some action points. Right now, what is the time? I think it is the time, few points I have got. First, I feel that biodiversity should be mainstream in economic planning. Whenever economic planning, we should keep an eye whether we are disturbing our biodiversity or not. That is my first point. My second point is that whenever we develop our infrastructure in urban areas, I think we should try to develop green infrastructure and we should ensure urban biodiversity, right? That is also important. Third thing, I thought that it's very important that we empower our indigenous and local communities. And I know CSIR is playing a very significant role in this area, through access benefit sharing, I remember the classical case of Kani tribes, where Dr. Pushpangandan had played a very significant role. You know, that tribe had certain formulation. He ensured that that formulation goes to the market and all the benefit goes to the public, right? That community. So we should empower our indigenous and local communities. Then we should, when we talk of today agriculture and land use, we should promote sustainable. We should ensure that we don't irrigate much or we don't under irrigate. We don't apply much chemicals. We should regulate, and it's important. And this is only possible, and I feel we should make conscious effort in educating and engaging. When we talk of biodiversity, when we talk of this year's theme, without educating and engaging society, it will not be possible. And all this should have the scientific research and innovation support. If you don't do that, I think it will be all washed away. Therefore, scientific institutions have very, very important role. And then we should, when we, when I started this talk, I said that we should focus on our SDGs and KMDBF role. So we do not only implement, but I think also monitor these targets. So monitoring part becomes so important. And in the last, I would say that when we talk about economy, and if it is based on native bioresources, that will be very, very important. So, madam, these were some of the points I thought that I should share with this whole group, and hope some new dimensions are added to it. And I must congratulate you and also CSIR in taking this effort so ahead. This is so important for our nation, which is one of the biodiversity rich nation. And now it's only time that we conserve it and utilize it sustainably, keeping in view those two important universal and international goals that I just talked of. So all the very best on this day, and let's hope that when we meet next time, some new things emerge. Thank you so much, and all the best.
Thank you. Thank you so much, Dr. Sanjay Kumar. As usual, we thought you'll come up with presentations and case studies, but then you took us by surprise by talking.
Madam, you gave me 15 minutes, so I thought that.
I know. But it was, again, a very enlightening lecture, no doubt, about the efforts and all. And you did mention the efforts that CSIR has been putting in. And, these forums are just to reinforce those efforts, even amongst the younger CSIR scientists who are joining in, scientists and technical officers who are joining in and who have joined the system. There is a legacy, and that legacy, of course, we want to maintain and take forward in whatever which way. So I thank you once again, Dr. Sanjay Kumar. And in case there is any quick comment from anybody, I think we can take just one such thing. But otherwise, there is a session, after the entire program on question and answers, where your questions and your doubts would be cleared by the experts. So I request Dr. Sanjay, please do stay on. I think Dr. Baleshwar has some comment. Yes, Dr. Baleshwar. He's in TKDL right now, Dr. Sanjay.
Okay.
Yeah, please. Baleshwar, you'll have to unmute, please.
Dr. Vibha, I just have to thank Dr. Kumar, because when I was at IIIM Jammu, I usually visit Himachal Pradesh, our ISBT, because we had to work in Lahaul Spiti. And every time in the morning, we all go to their field. So for the 9 years, every year we visited ISBT fields. And it is so beautiful that you will find such a plants in the field that we could not find in the field at high altitudes. And the labor, the inputs they had provided, and they supported the farmers in Himachal Pradesh, it is tremendous and example for other states. Thank you, Dr. Kumar. Namaskar, sir.
Thank you. And now, of course, I leave it to Bhanu to introduce our next speaker, Dr. Ranjana. Dr. Ranjana is part of and a partner of Remfree and Sagar, one of our impaneled attorney firms. And of course, Bhanu, you can take over in enlightening the audience on Dr. Ranjana's achievements so far.
Thank you, Dr. Vibha. I would take this opportunity to first thank Dr. Sanjay Kumar for his very illuminating talk. And going forward with the panel speakers, I would like to invite Dr. Ranjana. She is the partner of Remfree and Sagar attorney firm, and she leads the life sciences practice of Remfree and Sagar. She has been active in the field of IP protection not only in India and abroad in foreign jurisdiction, and has been on the forefront in addressing the issues regarding biodiversity also. She has organized programs on these and have been doing a lot of work on the related aspect. Dr. Ranjana, can you give your talk now so that and she will be speaking on the new Biodiversity Act 2023 and Biodiversity Rules 2024. So, can you hear us, Dr. Ranjana? I would like other participants to please mute their mic. Dr. Ranjana, please mute your mics other than Dr. Ranjana. Please, Dr. Ranjana, can you now identify yourself and
Yes, thank you so much, Bhanu. Thank you, Dr. Vibha, and thank you, Dr. Sanjay Kumar, for your passionate talk. That was quite enlightening. I was not aware of Mulaki. I have learned a lot from your discussion today. Thank you so very much. As Bhanu has explained, so today we are going to discuss about the recent amendment which have been done in the Biological Diversity Act and the rules. And now we have received the regulation as well in April 2025. Many changes have been conducted. Some are good to have. For some more deliberation, I'm talking about from my perspective, which require more clarity, more deliberations. As Dr. Kumar in his talk has mentioned, that we need to protect our resources. For that, we have made certain changes in the law, in the rules. The intentions are all good. We need to conserve our resources. We need to have a system in place for the benefit sharing with the right holder. But how we are going to achieve, what are the practical problems, how, the challenges which practical problems we are facing, and how to overcome that. Right from, in the amendment, whether the term byproduct has been replaced with derivative, how we are going to discuss and deliberate upon that, how much clarity we have today, and how much clarity we are going to have in future. More powers given to State Biodiversity Authority. The responsibility of certificate being issued by BMC for cultivated medicinal plant. Do they have enough infrastructure to issue or the knowledge to issue such certificate within the given short time frame? We have to look into that, how practically we are going to achieve that. To the decriminalization aspects, which have been the provisions which have been introduced pursuant to Jan Vishwas Act. We do have the authority in place, the framework in place, but how we are going to achieve that? I think the need of list of value-added products. Maybe the biological, the NBA feels that this is something.
A series of lecture. बायोडाइवर्सिटी डे जो था 22 मई को मनाना था, लेकिन किसी कारण से डिले हुआ, संडे को नहीं कर पाए, तो उसके लिए
there is someone who's please mute yourself. So these are the things we are going to discuss and deliberate upon today. So before we start, can you start sharing the discussion? I think a very brief introduction about the speaker, which Bhanu has already given to the and about the firm, just to give you the confidence that your cases are in safe hands. I'm Ranjana Mehta Dutt. I lead the life sciences practice of the firm, and it has been I'm a patent and design attorney, and I'm in the profession of IP since last 3 decades. I've been very active and instrumental in making many changes and amendments in the various acts and the rules and the provisions. Very quickly, I'll not take much time, just to those who are not aware of the firm. The firm was established in 1827, and we are going to complete 200 years of our existence in 2027, in another 2 years. So we have 115 attorneys with us, which includes 16 partners and a strength of 250 employees. We have offices in Gurgaon, Chennai, Bangalore, and Mumbai, the Gurgaon being the head office. So everything is being controlled from Gurgaon office. So not only other major jurisdictions of the world, we have a very close associates network in the subcontinent, where we represent our clients in all these subcontinent jurisdictions. We filed close to 5,000 applications in a year before the Indian Patent Office. So this excludes all the foreign filings which we do for our various clients. We have our relation with CSIR, I think, is a very old association, just because of our history. We have been working with the CSIR for I mean, my personal experience is I have been working with CSI for about 30 years, since the time I have joined the profession. These are the strengths of the firm.
Ranjana, can I just request you to put it in slideshow mode? Your slides are not moving.
Oh, okay. Just a moment, slideshow.
Thanks.
Can you see now? Is it okay? Is it moving now?
No, is it not? It is not moving.
Not yet. It's not moving. I just put it in
save
slideshow
your
mode,
entire
please.
screen.
Let me 1 second. From our end, it's fine. Let me call my expert here. Just a moment, please.
Yeah. What you can do is just unshare and share the full screen. Just unshare this.
Slideshow. They're not able to share. Slideshow nahi ho raha. Yeah, slideshow. Is it now moving? Are you able to see the slide?
No, we are not. We are seeing just the first slide.
Okay.
But beyond that, we are not seeing anything. So you'll need to unshare and share again.
That we have done. Let me check again, please. Sorry
Please
for the
unshare the slide. Please unshare the presentation.
Next slide. Are you able to see now?
No, I think you'll need to unshare your presentation. Just remove it from the screen.
हटा के दिखाओ। Save the save test.
आप स्क्रीन से अनशेयर कर दो ना।
हाँ कर दिया उसे। अच्छा अच्छा मैं कर दूँगी। हमारे साथ शेयर कर लो। हाँ जी मैं हाँ हाँ I'm sending it. I'm sending it. Just give me a few minutes. कर दिया मैंने उनके साथ शेयर. Let me see. Move the slide. Second slide. Is it? Can you see the slide now?
No, it is the same way it was before.
I've shared it with Kapil. Kapil, can you please? No, they are not able to see the slide. मैंने भेज दिया आपको. ईमेल किया. Mail. यहाँ पे हमको दिख रहा है बट वहाँ पे उनको खाली फर्स्ट स्लाइड दिख रहा है. हाँ. तो आपको यहाँ से हटाना पड़ेगा. लेकिन आपको फाइल आपको अपने डेस्कटॉप पे खोलना पड़ेगा.
अब गाने नहीं बनते. कहाँ पढ़ गया?
That will be helpful. रंजना आप लोग जरा एग्जिट कर लो and then rejoin. Yeah. Thank you. Mr. Raghuram. Dr. Raghuram.
Yes, ma'am. Yes, ma'am.
Yeah. So, sir, I think we'll go to you first. In the meantime, we'll just sort out.
Yeah, no issue, no issue.
No, they'll be doing. So you have to open. You can introduce.
Raghuram is there? So Dr.
Yes, ma'am, I'm
Raghuram is, Dr. Raghuram is from NBA. He has been serving NBA for more than 2 decades now, and he has been very active in the field of access and benefit sharing agreements. He will be speaking on the requirements of access and benefit sharing.
Ma'am, sorry to interrupt, but I have received the presentation in case you want me to share.
I think we'll go with Dr. Raghuram and then we can come back. In the meantime,
Okay.
looking at this patient can be on full screen.
Right.
Dr. If it's okay, we take Dr. Raghuram first.
Dr. Anjana, is it okay with you? We'll take Dr. Raghuram first. Dr. Raghuram, you can start your presentation. You will be speaking on access and benefit sharing process and requirements according to the new rules, Biological Diversity Rules 2024.
Thank you, ma'am. Am I audible, ma'am?
Yes, you are audible. Can be a little more louder if.
Yeah. Ma'am, how about the screen? Is it moving
It
fully?
Yeah, it is visible and it is moving. Please go ahead.
Okay. Thank you. Good morning, everyone. Myself, madam has introduced about me. I'm Raghuram, basically a marine biologist, but I'm working last 18 years in the National Biodiversity Authority and looking after the ABS mechanism all over the India. And what we are doing is we are implementing the Biological Diversity Act 2002. Today, I'm going to discuss about the access and ABS, access and benefit sharing regulation 2025. It got notified on 30th April. So that we're going to discuss it today. Before that, what exactly happened in the act changes, then in the rules, all those things I will slightly touch upon and move ahead. Coming to the national legislation, after India became a party to the CBD, after long deliberations, consultation, notified the act in the year 2002, rule in the year 2004, and ABS regulation in the year 2014. It was the previous story. But now the act has got amended in 2023, rule in 2024, and the ABS regulation in 2025. 23, 24 and 25 every year, each and on 23 act has got amended, 24 rule, 25 ABS regulations. So that has been completed now. Coming to the objective of the BD Act, today I am seeing senior scientists of CSIR, young scientists, those who have joined recently and mid of their career. I would like to place on this information that objective of the BD Act is conservation, sustainable use, fair and equitable sharing of benefits arising out of that. Already the first speaker, Dr. Kumar, has clearly mentioned, Sir was our authority member for a long time, and Sir knows better about the BD Act and how we are functioning in NBA, National Biodiversity Authority. So Sir has clearly spelled about today morning the international scenarios like Kunming-Montreal Global Biodiversity Framework, alien invasive species, and how species are important for our day-to-day activities and technological development and other things. So now I'm going to talk about only legal languages with you. Though I'm not a lawyer, I'm basically a scientific guy, but I will try to give a perspective about the legal mechanism in BD Act. So as I told you, conservation, sustainable use, and fair and equitable sharing of benefits. Conservation, sustainable use, everybody knows. Only thing is fair and equitable sharing of benefits. That is, it's a new term concept. That is what exactly it says. If a company accessing any biological resource, if a scientist accessing any biological resources, they have to share their benefits with the provider. Provider may be a community, provider may be a CSIR agency, or provider may be an ICR institute, university, whoever it is, they have to share their benefits. The benefits may be a non-monetary or monetary. This concept only NBA is implementing under the Biological Diversity Act. If you see the objectives of the Act, I hope you can see the pyramid structure in the screen. Can anyone confirm me that my presentation is moving?
Yes, it is moving.
Oh, okay, thank you. If you see the pyramid structure, the base one, the base level is BMC, Biodiversity Management Committee. At the village level, 7 people committee should be formed accordingly in the year 2016-17, based on the court direction across our country. 2.77688 lakh local bodies created or constituted the Biodiversity Management Committee. That is village level body which will govern the biodiversity conservation and sustainable use. And they are playing a major role. Today we are talking about SAR's. Today Sanjay Kumar sir mentioned that how we fought in the court of law for that revoking of Haldi patent and all. How CSIR played a role in that. So all those things were done. What the court asked, where is the written proof for that? That written proof is, we took a palm leaf and translated all those stories, you all aware. But in order to avoid such misappropriation, under the BD Act 2002, the National Biodiversity under the BD Act, they have brought out a concept called PBR, People's Biodiversity Register. People's Biodiversity Register. In that register, all the local body should document the information about the biodiversity, traditional knowledge, who is doing that, oral as well as coding or uncoded traditional knowledge should be recorded. So as on date, we are close to 2.65 PBRs have been documented across the country. So it's a great achievement. Now the National Biodiversity Authority, with the support of the NIC, National Informatics Center, Kerala, we are translating that into the electronic format, that is called ePBR. Manual PBR has been prepared. Now we're going to do it as an electronic PBR. Of course, in fact, the PBR is not a static document, it is a dynamic. Once in 3 years or once in 5 years, we have to do this exercise. In the last 10-15 years across the country, under the Green Skill program, whoever got trained, barefoot botanists and NGOs were involved in this exercise and documented the PBR. We have, every state is having a state level monitoring committee also for that PBR, how it is effective, quality wise, and the information wise, how this PBR can be utilized, and all the state level monitoring committees looking after. So village level, local body level, we have a BMC, State Biodiversity Board. SBB means State Biodiversity Board. All the union territories and states, we have a State Biodiversity Board. National Biodiversity Authority is the apex body. We are coming under the Ministry of Environment and Forest and Climate Change. Coming to the functions of BMC, you can see on the box regulatory, advisory, and facilitative. These are all the roles are there. Regulatory is very important. That is granting approval or rejecting the application forms for access to biological resource and associated knowledge, and issuing guidelines, notifying threatened species, and declaring the biodiversity heritage sites. All those things are all there. Issuing guidelines to the BMCs and the SBBs are all the one of the functions of NBA. We are doing that facilitative job. Coming to the State Biodiversity Board, we are also they are also regulating the access, and they have to advise the state government on biodiversity related matters, biodiversity conservation, heritage sites, and threatened species. Functions of the Biodiversity Management Committee, BMC, they are having a important role in this exercise. NBA or SBB, either one of us, before giving approval to any company, any scientist for accessing a biological resources, we supposed to conduct a consultation, or we have to obtain their consent from the BMC. If the BMC says no, we should not allow this company to access the biological resource, then NBA and SBB's hands are tied. It is very difficult. In the past, I can give a number of examples. Even the wild brinjal varieties from Karnataka, all these places, one university, Ohio University of America, Alison Snow, you can also browse it in the, since she is an expert in that field, Professor Alison Snow. She tried to get the material from wild brinjal varieties in the year 2011-12 from 3 different places of South India, but Kerala, when we referred the matter, the BMC said no, wild brinjal variety should not be given to non-Indian or foreigner. So accordingly, we have informed that foreigner that you should not collect the material from Kerala. Rest of the places you can collect it. So why I am telling this story, why I am telling this scenario, BMC is very powerful in the field. That is what I am trying to say. At the same time, they have to prepare a people's biodiversity registration in consultation with the local people. Now, greater awareness have been achieved. Awareness has been achieved across our village level because of this exercise. Of course, we spent around more than roughly, I'm telling 80 to 100 crores rupees we have spent for this BMC strengthening awareness creation and documentation of PBR. These are all huge exercises with the generous funding from the Government of India and from other international agencies, UNDP, GIZ, JEF. All those projects also helped us to move ahead on this subject matter. So now I have given you some idea about what is BMC, what is State Biodiversity Board, and what NBA is doing. So it's a 3-tier structured mechanism under the BD Act for biodiversity governance. Coming to the need for amendment, when the Act has been implementing, we found some issues, or we found that some difficulties. You all know that when the trends are being changed, we have to move it accordingly. So the concerns raised by different stakeholders, including research sector, we invited CSIR scientists to our consultation exercise since 2019 to till date, till 2024 December, we had a lot of consultation with the stakeholders, Ayush sector, then agricultural sector, pharma, biotechnology, whatever it is. I can name any agencies like ABLE from Bangalore, Indian Cosmetics Association. All were invited across in the last 5-6 years, and we consulted before amending this act. So including CSIR, I am telling. Coming to the major amendments to the BD Act, hope my slides are moving. I am in the major amendments in the Biological Diversity Act. new definitions have been included. We are talking about access and benefit sharing. What is access? Codified traditional knowledge, derivative. Of course, previous speaker from patent attorney said that derivatives and these kind of points have been mentioned. Then Indian territory, member secretary, these are all things. Even the benefit claimers and biological resources also, they have slightly modified. Important thing is definition of foreign entities has been changed. What is that definition? What they have mentioned earlier in the 2002 Act, it says even if a company is having a 0.0001% foreign shareholding, then that company or entity will fall under the ambit of Section 3 and should take approval from the NBA. Now in the amended Act, it says that as per the Companies Act, section class 27 or section 27, section 2 of class 27 says that if it is controlled by a foreigner or a foreign company, then only it will come under the purview of the section 3. Otherwise, they will be treated as a section 7. It's a major change we have made it in the section 3. And you know that codified traditional knowledge, cultivated medicinal plants and its products are exempted under section 7 if it is notified. And very important thing is the moment we are saying cultivated medicinal plants, how do we know that it is a cultivated? For which section 7 clearly says certificate of origin should be obtained by a company from the Biodiversity Management Committee, for which Rule 19 has been prescribed. Rule 19. And major important thing is, for example, CSIR as on date more than 900 applications, more than 1000 I can very well say. Till 2013-14 itself, CSIR across your thing, we have received more than 500 applications for especially for patent. So the third bullet point, if you see, a simplified procedure has been introduced in the form of registration to Indians before obtaining patent. Section 6(1)(a) clearly says if you are an Indian scientist, Indian institute, CSIR, all should only registered with the NBA. That registration certificate will be issued. That is more than sufficient. No agreement to process and all. Earlier, CSIR or whoever it may be, there are a lot of office orders have been issued under the CSIR. ITMU team and the head of the CSIR has delegated the power to officer who is in charge in respective labs. For example, NBA is located in Chennai. Opposite to our office is the CSIR Structural Engineering Unit. From that, in that structural and Leather Research Institute is on another side. There, the in charge director level or additional director level, they used to come to our office and enter into agreement with them because the agreement can be signed by them due to one order. I faintly remember in the year 2000, only in the NBA, CSIR and ICR institutes have applied for the patent, and that ICR application is less than 100. But yours is CSIR is more than 1000 applications we have received so far. And for which agreement and all you have to sign earlier act as per the previous act. But in the present one, there is no such requirement, only a registration. Only thing is in the registration earlier, anyone, even if it is a non-Indian or Indian or foreigner, whoever it may be, they have to pay only 500 rupees as an application fee. Now that application fee has been increased to 2000 for individual and 5000 for companies. That I will show it in the tabular column. Then cultivated medicinal plant I've touched upon. BMC should maintain a books. All those things have been clearly mentioned in the rules. Rules In the year 2024, we brought out how to maintain the book, who has to maintain, all those informations are available. Then now this slide is over. I'll come to another important one. As I told you, in Government of India, India is a party to the CBD. CBD's protocol, two protocols are there, Kyoto Protocol and the Nagoya Protocol. Nagoya Protocol talks about ABS. So that ABS, Nagoya Protocol, mandates the country that the country should monitor the biological resources which are coming from outside their country. It means if a company, the company accessing the biological resource from China and using it in India, it is mandate. It is an obligation on the part of India to monitor that biological resource, whether those materials have been accessed in a lawful manner or not, for which a separate form has been introduced in the BD rules. That I will show it. And then cultivated medicinal plants, section 40, it's section 40 is a very important section wherein if ministry or Government of India decided any species to be exempted, that they can do it. It is an enabling clause for the government to do so. As on date, we have exempted 422 or 23 species as a normally traded as commodities. For that species, no approval is required from NB or State Biodiversity Board. But in the amended act, it also included some agricultural waste, cultivated medicinal plants, and other things can be notified as under section 40. Another important section is section 55A, appointment of adjudicating officer. Till 2023, all violations are treated as criminal offense, non-bailable offense, that is criminal and non-bailable offense. Now that has been diluted as per the government's policy decision, and any violation, adjudicating officer will deal that, and section 3, even the IPR violation or access violation, research violation, sorry, commercial, whatever it is, that will be addressed before the adjudicating officer. Adjudicating officer also appointed by Government of India. Joint secretary level officer who is dealing the subject matter in the ministry is the adjudicating officer. That notification also came in the month of January 2025. The penalty is concerned, the penalty may go up to 1 crore. Even if the damage is more than that, then it will get increased. This penalty is not inclusive of ABS. If any due in the ABS, for example, 5 or 6 years, the company has not taken any approval from NBA and doing their commercial activity, the ABS due, whatever they have to pay is different, and this is an penalty only. As I told you, on 10th January 2025, the Government of India notified the adjudicating officer, also notified the state level adjudicating officer. The state has to notify on their own. That provision, delegation of power has been given to them. Coming to the act, I told you what are all the subject matters are covered in that. The first one, hope you can see the scope of the act, activities regulated, type of person. If you see that, what is scope of the act? Biological resource. Biological resource means what? Plant, animal. The word starts with including biological resources, including plants, animals, microorganisms, derivatives, etc. So it will not value-added product is exempted, as well as human genetic materials are exempted from the purview of the act. But at the same time, people are coming out with a question saying that asking that, sir, I am collecting a SARS virus or COVID virus, chikungunya virus from the human blood. Since I am accessing the human blood, it's a human genetic material. It will, so your act will not attract on this particular aspect. Act is very clear. Only the genetic material of the human genetic material will not come under the purview, whereas the microorganism or whatever other species are available in the human body, that will come under the purview of the BD Act. So accordingly, any COVID virus or chikungunya, whatever it is, rotavirus, for those and all, in the past I'm telling, I'm naming the company also, Invent Price, or I can say Bharat Biotech, all have got approval from the National Biodiversity Authority. The biological resources are have accessed from the human body only. So our act talks about biological resources and associated knowledge. Associated knowledge is a very broader term. Contemporary as well as the traditional, both will come. And you all know CBD in the year 2020-24 December, November in Cali, Colombia, under the 16th Conference of Parties, they decided that DSI will also come under the purview of ABS, digital sequence information. Not only CBD, even if you go recently adopted, Ministry of Health Affairs was the nodal agency for that. Pandemic agreement for dealing the COVID related matters. The pandemic agreement adopted by the WHO is also having that sequence information. Digital sequence information is now available in 3 agreements. To my knowledge, one is CBD's under the Nagoya Protocol, it is there. WHO pandemic agreement adopted last month. Then one more thing is UN class, United Nations law on seas. In that also, marine biodiversity beyond the national jurisdiction. That treaty was adopted in the year 2023. There also digital sequence information has been included. So digital sequence information, if you are accessing and using in your product or on your research, depend on your status, you have to take approval from the National Biodiversity Authority or State Biodiversity Board. What are all the activities we are regulating? Research, biosurvey and bioutilization, commercial utilization, obtaining IPR, transfer of results of research. And for Indian CSIR scientist or ICR scientist, if you want to carry a biological resource for your internship program or short-term courses outside India, then you have to apply under Form 13. Now it's a Form 13. Earlier it was Form B. That you can do it. And the last one is deposition of microorganism for claim novelty. As per the International Bacteriological Nomenclature Code, Article 27 says that you have to submit the voucher specimen in 2 different places. One is the place where you have identified in India, another one is outside the country. Then only your novel strain will get published in the journals, for which also we are facilitating. There is a separate form available for that you have to, of course, if your scientist wants to do so, you can do it. Your microorganism CSIR lab, I know one of our member, Dr. Alka Rao, knows better about this thing. And one more thing is Dr. Suresh Karpule from CSIR Chandigarh lab. Much before, I am telling 2008, 9, 10, Dr. G.S. Prasad, now Sir has become professor in JNU, Hyderabad, I guess. So their inputs were taken and the NBA developed a strategy and developed a form, application form for it, just intimating, no application fee, nothing, only intimating through online. As on date, more than 350 such requests. Intimation we have received that biological resources are microorganisms are submitting outside India for claiming novel strain. In this act, only two persons are there. One is, I'm telling, Indian, non-Indian, Indian, non-Indian. How they are all differentiated. If you see section 3, I'm in the slide. I hope I'm audible and the screen is visible. Can anyone?
Sir,
Sir,
yes, you are
the
audible.
screen is not moving.
You are audible and
Thank you.
visible.
Section 3(2) means you can simply take it that they are all non-Indian. NRI, non-Indian, individual, entity, as well as the company who is located in India having foreign control. That you all know that more than 50%, if any company is having, then that company alone will have a stake on that subject matter, stake on that company. So that is a foreign controlled company. Section 7 means purely Indian company, 100% Indian company, Indian. Even CSIR scientist will also come under the purview of section 7. Whereas section 7, it's in the present amendment for undertaking research, biosurvey and bioutilization by CSIR scientist, no approval is required. Only for obtaining a patent in or outside India, you have to register. Once that patent, you obtain the patent, and while transferring or while you are transferring or commercializing that patent on your own or pass on to some other company on a lease license basis or rights basis, that time you have to apply again to the National Biodiversity Authority. By the time alone, the benefit sharing will be fixed and the agreement you have to sign. Not at the time of applying application as you done in the past. Only before commercialization you have to take approval from NBA. Now you have to apply for registration. Second is for commercial utilization. While doing commercial utilization, before commercial utilization, you have to take approval, not registration, approval, and approval will be in the form of an agreement. You can park your questions so that I will respond to you once immediately I have completed. These things you all aware, section 3(2), I told you. Companies earlier 0.001%, if any foreign institution having share in the company, then that company will be fully falls under the section 3(2). For every activity they have to take approval. But section 7 means you have certain flexibility. Section 4, I am telling the transfer of research result. Mostly I am not seeing the CSIR doing this exercise. ICR is doing. CSIR, I am not finding any know-how technology transferring. If you are doing so, know-how technology transfer and any kind of royalty you are receiving, then the CSIR scientist or particular lab, you have to apply in the form 4, I guess. Yes, I will just show it in the next in another 2-3 slide. Indian or non-Indian transferring, you can see on the right side after Indian or non-Indian transferring results of research to any non-Indian requires prior approval of NBA. I could see Madam, I forget, ma'am is sitting in the along with Banu Madam. She knows that Ashika Rastogi ma'am is also sitting. She was the one in the last, I am telling, 15 years, close lies with our National Biodiversity Authority on IPR related matters. Ma'am is also fully aware about what is our requirement, how we are processing. She knows our plus and minus very well. Receiver, here the red color points are all, I'm telling you, these are all newly added. The transfer of research result, receiver, if he wants to do further research on the results itself, no bioresource, only result. With the result, if they are doing any research, then they have to do registration. But the same research of result, if they want to do any IPR related patent, all those things, then approval is required. That is very important. Coming to the collaborative research, I didn't see in the last 18 years of my service, CSIR has submitted any collaborative research thing. But collaborative research projects, international collaborative research projects are all exempted. I know 2-3 projects about CSIR. Sorry if since you are all CSIR scientists, I'm telling. Procter & Gamble using headspace technology in some Kurunji flower or something with the Palambur HBT, Sanjay Kumar sir, Dr. Sanjay Kumar sir knows better. You had a tie-up with the Procter & Gamble company, I guess 2005, 6, 8 period. And some more companies I still remember, Novozymes or somebody. So these kind of things, if the government approved, then that is exempted from our purview. That Procter & Gamble company need not apply to the National Biodiversity Authority, for which a separate declaration is there. In that declaration, CSIR institute concerned ministry, Department of Ministry of Science and Technology, I hope you will fall under that ministry. There you have to get a signature and send it to us. So that is exempted from our purview approval. I told you, since IPR is the major subject matter here, once again I am stressing that Indians only registration. Serial number A. Serial number B, Indians to take prior approval at the time of commercialization of IPR. Non-Indians, prior approval to be obtained from NBA for obtaining IPR. So non-Indian as concerned, there is no excuse, only for Indian slight mileages, slight lineages given. Otherwise, for non-Indian, there is no this thing. And another important thing is biological resources deposited outside India will also covered under this. Earlier also it was there, but now the Act has clearly spelled out that even if you are accessing a biological resource from American type culture collection or from Korean type culture collections, any museum where Indian biological resource, if you are accessing and doing it, then it will attract the provisions of the BT Act. Nagoya Protocol very clearly says if anyone, attorneys or anyone wants to check it, go to the ABS guideline issued in the year, a question and answer type of FAQs I can tell, issued by Ministry of Environment and Forest in the Japan, then in Germany, EU. They are very clearly stating that the repositories are intermediaries only. They are just having the material on with them. It doesn't mean that the repository is having their custodians. Ma'am, sorry, I'm taking much time.
Yeah, so you will have to now summarize.
Yes, ma'am. Yes, ma'am. I'll finish it up. Exemptions rule. This is how these are all the application form. This slide I will leave it to Banu ma'am. Then ma'am can circulate in the form of a PDF. But this PPT can be used for a reference. Don't think that this is the one ultimatum. You have to refer always Act and rules only. You can see earlier 180 days we took to clear any application for research, all those things. Now that has been reduced to 90 days. Under ease of doing business, Government of India has formulated, streamlined the regulatory mechanism. It's a boon to the industries, research scholars and others. And application fee slightly increased. Earlier also the person has to pay 10,000 for research, foreigners. Now for entity 20,000 we have slightly increased. But the patent is concerned 180 days. Of course, the DPIIT requested the National Biodiversity Authority during the discussion. That's the reason why we kept 180 days. Rest all will complete within 90 days. Application forms are all filed through online only. That you know well. Again, this is transfer of results of research, registration, then IPR if they want, they have to take approval. Days have been reduced except in the IPR related matters. Rest all from 180 days to 90 days we have reduced. This is not having any this thing. Adjudicating officer is nothing but this one thing. I'll quickly go to the here. If you see the ABS regulation, it says 0.2% as per the MSME concept, micro, small, medium enterprises. The government of India 2020 they have brought out the MSME category. Accordingly, we have revised the slab. The company's turnover is, if it is a 5 crore till up to 5 crore, the benefit sharing is nil. But above 5 crores to 50 crores, 0.2%, 50 to 250, 0.4%, and 250 above 250 crores, 0.6%. If you see any international this thing, it will go up to 2% of the sale proceed. All those things are there. Even the recently held CBD's DSA ABS mechanism also talks about 0.5%, 0.6%, 1%, up to 1% they went, but here it is only 0.6%. 1 crore below companies are all completely exempt and they have to submit, they need not submit anything. Above 1 crore to 5 crore, they have to submit a consumption data to the NBA or SBB. And if it is a biological resources, a threatened species or anything like red sandalwood, agarwood, they have to pay 5% of the sale proceed. As on date, the NBA has collected nearly 120 crores as a benefit sharing from the access of red sanders. All red sanders have been purchased by, accessed by Chinese companies in the last 8 years, 2016 to till date. Chinese companies have access from Andhra Pradesh. That is a thing. And one important thing is the BD rules 2020 regulation 2025 also given that within the 15 days state biodiversity board should clear the application, otherwise it will be treated as a deemed approval. Again, it's an important thing for the companies to get a clearance immediately from the SBBs for their business, for which also we have given a application formats have been designed. With this, I am patent as concerned. I told you up to 1% it will go on the annual gross factory sale price of the product. On that product, Amway product means Amway has to give for each and every product up to 1%. The NBA will fix that percentage based on our experience and the expert committee's view. And if the product or process licensed, then it should be up to 5%. Royalty up to 5%, maybe a 0.1 or 0.2 or 2 or 3, it depends on the things. Fine. This is the one. And enough flexibility will be given for the COVID kind of things and environmental related problems, anything IPR patents on environmental related issues, concession will be given. So with this, I am stopping my presentation. Sorry, I took much of your time. Thank you, ma'am. Thank you.
Thank you, Dr. Raghuram. You share the slides with us so we can circulate it amongst our scientists for better utilization.
Thank you, ma'am. Any questions, ma'am? Otherwise, I will be available in these
questions we can take after all the three panelists speak. I hope that will be acceptable. So we can collectively ask questions in the end. I'll call upon Dr. Ranjana to give her talk on BD Act and BD rules, specifically addressing the issues of foreign jurisdictions also. And Dr. Ranjana, I would request you to limit your talk to not more than 20 minutes.
Yes, I will be sharing.
Okay. Actually, we will not even take down 20 minutes because all our points which we had to, Dr. Raghuraman has already covered in his presentation. So that thank you, Dr. Raghuram, for clarifying certain things, but we still need clarity. So I think we can only discuss from attorney's viewpoint the challenges which we are expecting to be there. And all the questions will be directed to Dr. Raghuram in this regard. So can you please share the slides?
Yes, I'll be sharing the slides. So is the presentation visible?
Yeah. Yes. So I think you can simply skip the introduction part of the firm as well due to the paucity of time, and we can simply skip to the.
Yeah, I understand. Is first of all, if it is in slideshow mode?
No.
Oh. And is it moving?
Yes, now it's moving. Can you just skip this? This is about the form
Okay.
which I'm already.
Okay. You guide me accordingly. I'm in the third slide.
Yes, you keep on skipping. I'll stop you from where we would want to start.
Right.
This talks about our strengths and what we all do in the firm. Yeah, you can move to next slide, and we'll start simply discussing the. This is all what we do as IP boutique firm. All the different. I know that's okay. It just mentions that what all we do. Next slide. Yes, so we are going to, as I explained, we are going to discuss the key amendments. What are the challenges which can be there? So I now introduce my colleague, Ms. Payal Kalra, who is a senior biotechnologist and takes care of NBA portfolio within the firm. So over to you, Payal.
Thank you, Ms. Mehta. A very good morning to everyone. We are still in the morning today. My name is Payal Kalra, and I'm a partner with the firm. Thank you for giving us this opportunity to be part of this program. We also apologize for the technical glitch that has happened in the morning. So I will, as Dr. Raghuram has already set the tone for the amendments that have happened.
Payal, you are mute.
Not it. Now can you hear us?
Right. Yeah.
So am I audible?
Yes, you are audible.
Can you?
Yes. Can you move to next slide?
Yeah. So just to give you a brief background, India ratified the Convention of Biodiversity and Nagoya Protocol. The basic objective, as we all know, were conservation of biodiversity, and then sustainable use of the products of biodiversity, and again the fair and equitable sharing of benefits arising out of the use of these components. So based on these objectives, the Indian government framed the Indian Biological Diversity Act 2002, 2004 rules, and the ABS guidelines of 2014 to fulfill these purpose of the objectives of the biodiversity CPD and Nagoya Protocol. So India could meet these objectives fairly well, but then what was the need to amend the sections, amend the rules, and come up with a new act? Basically, there have been a lot of concerns that were shared by various stakeholders, including the Indian system of medicine sector, the seed sector, the industry sector, the researchers over several years. Like they wanted to have the process more simplified. There should be less compliances, and the patent grant process should also be simplified. So based on these issues and concerns that were raised, there was a Biological Diversity Bill 2020 bill that was formed. Then there were, again, it was open for public comments and stakeholders meeting. And after that, there was a joint parliamentary committee that also scrutinized these issues in detail. And finally, in 2023, a revised bill was presented, which was later passed by both the houses of the parliament, and finally it became an act in 2023. So with this background, I will just quickly touch upon the important changes, the key amendments which are important and relevant from the perspective of CSIR and other research institutes. So as we all have heard also from the previous presentation that the definition of benefit claimers that has been revised now, and it now excludes the codified traditional knowledge. So it basically, the Act now recognizes our traditional practices which are already documented and to ensure the development of our Ayush industry. In the definition of biological resources, there have been one significant change that the word bioproduct, which was earlier there, has now been replaced with the word derivative. So this derivative term actually was there in Nagoya Protocol. So it means that naturally occurring biochemical compound or metabolism of biological resources, even if it does not contain functional units of heredity. So I will take this in my next slide in detail. So just I want to highlight here, I mean, for the our audiences and those who are still new to the Act, that the human genetic material is not part of the biological resources. So this is something one can keep in mind, that if you're working on human genetic material, you're excluded from the provisions of the Act. Now, the term access, again, it was used within the Act on many occasions, but this term wasn't there in the definition. So this new term that this has been defined, and it says that means collecting, procuring, and possessing any biological resource occurring in or obtained from India or traditional knowledge associated thereto for the purpose of research, biosurvey, or commercial utilization. So this word possessing, which is there, like if you are already in possession of the material, then also it would be considered as access. Though the Act in the rules, this has been regularized, that those who were in possession of the biological resources prior to 1st of April 2024, they have now been given opportunity to seek approvals. So that part they have been taken care of in the rules section. Can you please change the slide? Next slide. Yeah. So with these amendments, I believe that the definition of biological resource has been expanded, because derivative, it is not only covering the primary source of the biological material, but also the metabolites, the product of metabolism. And even if it does not having the unit of heredity, it will still be considered as a biological resource. For example, if you have neem diazodirectin, which is its metabolite, would also be considered as a biological resource. But as this also highlighted that there could be some overlap also, as we believe, with respect to value-added product, because value-added products, on most of the occasion, we always have this issue both with the patent office as well as with the authority, like what exactly would come under the value-added product, because whatever we say, that will always be considered as a biological resource. So definitely, we would expect a more clarity, maybe an exhaustive list from MBA that could be circulated, that could be notified, that may ease the process. Next slide. Yeah. So Section 3 also, as we know that there have been substantive amendments that have been done, which definitely are positive. Because earlier, this Section 3, which basically talks about the foreign entities, what all constitute foreign entity and what are their obligations. So a person who is not a citizen of India, a citizen, a non-resident Indian, a body or corporate which is not registered in India, or which if it is registered in India, earlier definition or earlier Section 3, it states that any body corporate which is registered under any law for the time being in force, which has any non-Indian participation in its share capital or management. So if the Indian company registered in India having shareholders from as foreign resident, that was falling under Section 3(2) company in the erstwhile Act. But now with the revision in this part, now it has been linked with the Companies Act, and it says unless those foreigners, they have control in the decision making, in the appointment of board of directors, only then they would constitute as Section 3(2) companies. So with this change, next slide. This is really a positive change. Next slide, please. Yeah. So now there would definitely be shift of many Indian companies, which were previously under Section 3(2), they will now move to Section 7 companies or the Indian companies. So automatically their obligations would change, and those companies may now reach out, or institutes possibly may now reach out to NBA so that because their reporting would now be with the state biodiversity boards and not with the NBA. So that is one thing that you can review the portfolio and see if there were some collaboration with the foreign companies or foreign institutes, for the Indian companies which were previously considered as Section 3.2. Now coming to Section 7, because Section 7, basically we always say that Section 7 covers the Indian, it is for the Indian companies, Indian residents so Section 7 also there have been substantive amendments because now it says definitely Section 3.2 companies are not falling under this provision. So now the commercial utilization, of course the Indian residents are free to do research. Indian researchers are free to conduct research on the Indian biological resource. When it comes to commercial utilization, a prior intimation to the concerned state biodiversity board is required. Apart from that, you can see that even the codified traditional knowledge, it has been excluded. The cultivated medicinal plants and its products, they have been excluded. Earlier, the exclusion was only for bad hakims and the growers and cultivators of biodiversity. Now it has also been extended to the registered Ayush practitioners. So again here, this is to promote the Ayush industry and also to ease the burden on the wild varieties, the cultivated medicinal plants, they have been exempted. But with the rider, because if you are using a cultivated medicinal plant, you have to seek a certificate of origin from the BMC, respective BMC, as per the manner which has been prescribed. And BMC also has to maintain a record in the prescribed manner, which is provided in the rules part. Can we move on to the next slide? So the rule 9, which basically provides the complete process of how to obtain the certificate. Though there are, as per the records given on the NBA side, we have at present 278,000 approximately BMC bodies. But then the question arises, how many of them are actually functional and how many actually have the bandwidth to issue such certificates? So this could become a time-consuming process because those are sections. The rules clearly states that if you are not able to get the certificate within 15 days from the BMC, you can move to the State Biodiversity Authority and then to the NBA. But again, from the applicant's point of view, this could become a little cumbersome process, a time-consuming process. One has to give a declaration on Form 11 in this regard. Can you move on to the next slide? Now, just a quick recap of what are the obligations both for Section 3.2 and Section 3.2 companies. The moment you have to even touch the biological resource from India, you have to take permission. Right from starting from research, prior approvals are required, biosurvey, bioutilization, for commercial utilization, and for obtaining patents, for obtaining IPR. A prior approval is needed. But when it comes to Indian entities, no research, no biosurvey, bioutilization, no approvals are required. For commercial utilization, only intimation to SBB as per the provisions of Section 7. For IPR also, only registration. I'll touch this in my next slide in detail. Only you have to get the registration done. Next slide, please. So Section 4, which again is very important and relevant in the context of the research institutes, because there are many occasions when the research of the results, they are being transferred to foreign entities, foreign universities. So earlier, the burden was only on the transferor, like any Indian or non-Indian transferring the results to any Section 3.2 prior approval of MP is required. But now, there have been separate forms. We can move on to the next slide, please. Next slide. Yeah. So now there have been as Rule 15. Basically, it provides various forms and the obligation on both the transferor and transferee. Like you have Form 3. Like if prior approval would be required if any entity is transferring the result to Section 3.2 for commercial purposes. Form 4 is required by a registration basically by the transferee is required to use those results of research for further research if they want to go ahead with further research on it. If the Section 3.2 entity again requires to use those results for commercial utilization, then again a prior approval is needed on Form 4, Form 5. And if an IPR is desired, a patent it needs to be filed based on those results. Again, the Section 3.2 company, the transferee would be required to take prior approvals on Form 6. So these are the like now the you have specific access and benefit sharing agreements also associated with these approvals. Next slide, please. So Section 5 basically it talks about the collaborative research. So it basically covers that the certain provisions will not be applicable in case of collaborative research which are as per the guidelines of the central government. And earlier the provisions were both Section 3 and Section 4 that were not applicable. But under the amended act, only the provisions of Section 3 are not applicable. But if any transfer of research results are done, then necessary approvals as per Section 4 will be taken. So here, I believe that the process they have expanded the process in this, and the whole idea here is to basically encourage the collaborative research and putting India on a better footing at the international forum. Next slide, please. So this is Section 6, significant changes from the perspective of Indian residents or Indian entities have been carried out in Section 6. So Section 6, basically earlier the owners to obtain prior approval was both on the Section 3.2 entity as well as Section 7 entity. Both the foreign entities and Indian entities were to take prior approval of NBA before obtaining grant of patent. This process, of course, was cumbersome and also delay the grant of patent. Now, only the Section 3.2 entities, still they have to take the approval of NBA, but Section 7 entities, the Indian entities, they only have to take, they have to get this registered with the NBA if they are filing a patent application before grant. So, based on my recent conversation also with the IPO, this has really expedited the process, as many of the cases that were previously stuck, because it is easier, the process is simplified to get a registration from NBA, when it for the Indian resident under Form 8, and it has really expedited the grant, and of course the backlog is also coming down. But can you move on to the next slide? So Section 6 also, now specifies that the information which was earlier also there in Section 6, but now as per Rule 6, this word information, it is now being specified as digital sequence information. So even if you are not using the physical, biological material, but you are using it in the form of, some DNA, RNA codes, that also becomes a biological resource. So if any, foreign company is using such digital sequence information, which is based on Indian biological resource, that also constitute, a prior approval that requires prior approvals, before seeking grant from NPA. And also, it also clarifies that, the biological resources which are deposited outside India in repositories, but which are of Indian origin, that also comes under the purview of Section 6. So this is a very common problem, because we practically have come across various queries from our clients where they are though procuring the material from repositories outside India, but when they inquired about the origin, that origin comes out to be India. So one has to be take that also into consideration. If you are obtaining any biological material from outside repositories, just ensure that what is the origin. Respective forms, Form 7 is for Section 3.2 and 7 and 8. One more point I would like to clarify, that once the patent is granted, but if you want to commercialize your patent, then you need to take, the Indian resident need to take prior approval from NPA. Now, it is very important that if you really intend to commercialize, go ahead and take prior approval, because in the Patent Acts, we have Form 27. Once the patent is granted, definitely the patentee would be under an obligation to file Form 27 every 3 years. So there you have to disclose that, whether you are working, the invention is worked upon or not. So that could be one of the checkpoints that whether you are commercializing your patent or not. So from that perspective, it is important that if you are commercializing your patent post grant, then take approval on Form 9 and fulfill the access and benefit sharing criteria. Next slide, please. Section 36A, which was not there in the Principal Act, this has been added in the BD Act 2023. And here, basically, the objective is to monitor and regulate, the use of foreign biological material in India. So there has to be a declaration that needs to be submitted on Form 10, disclosing the details of the foreign biological, and it applies both to Indian entity as well as the foreign entities, and also it covers all the three aspects, like if you're using it for research, for commercial utilization, or for IPR. So, but as I mentioned earlier, always ensure that what is the source and origin of the biological material. There could be a possibility that you are maybe taking it from India, but it could have an origin of some other country, or maybe you're taking it from outside repository, but it has an Indian origin. So that point you need to check. And from the practice viewpoint, like, I mean, you can start maintaining your data regarding, like, if you're obtaining any sorts of, primers or, props or any enzymes from outside. So just maintain a dossier about their sources as much as you can. Although this could become a cumbersome, because in the research relating to life sciences, the one uses a lot of biological material, and they obtain it from the foreign countries and they have foreign origin. Next slide, please. So section 40 was already there, and it covers the exemptions which are there from the provisions of the Act. So previously, the normally traded varieties were exempted, and there is a list of around 421 biological resources. They were notified by notification in 2016 and 17. So as to promote trade, and also to for that was the objective. But now this has been extended to even the normally traded commodities as well as the items derived from them, and it also now covers, this section covers the agricultural waste. So agricultural waste have also been exempted. Apart from that, in alignment with section 7, the cultivated medicinal plants and their products, they have also been exempted. So again, here the intent is to reduce pressure on the wild varieties. But I have two concerns from the attorney's point of view, that the agricultural waste, again, it has not been defined. And secondly, that, what was the reason of not including the other biological waste that could also be considered and exempted. But the moment you use these MTAC varieties for patents, if you do an R&D around it, come up with some innovative product and file a patent application, you will not be exempted from section 40. The necessary provisions would be applicable as per the statute. Next slide, please. Section 55, as we have discussed in length, that earlier also, that it covers the penalties, and now the penalties are only civil in nature. We have complete criminalization. Earlier there was some, the penalties were different both for section 3.2 and section 7 entities, but now it's only monetary in nature. The fines, they are stringent, but they are same, starting from 1 lakh rupees to 50 lakh, and for repeated offenders, it reaches to 1 crore rupees. Also, the section 55 now provides the provision for appointment of adjudicating officer. And as Dr. Raghuram also shared the notification that in January the adjudicating officers, they have been appointed. And can we move on to the next slide? So these amendments are really welcoming, because of course there was a scare among various foreign entities as well as the Indian companies regarding the penalty in the form of imprisonment. There are rules now which are there, which provide the manner of appointment as well as the how the quantum of penalty that will be determined. So any order of intruding officer is appealable. It can be filed, and hearing will also be given before imposing any penalty on the applicants. Can we move on to the next slide? Yeah. So Section 59A, again, it wasn't there in the principal act, but it has now been incorporated, and it also covers basically the
He's not able
earlier
to. Excuse me.
the overlap.
Can I just enter? Yeah. I would like you to summarize now because we are gone beyond the time scope.
Yes,
We have one more speaker
So-
now.
Yes,
Just
sure.
summarize.
So
yeah.
yes, so this is a newly inserted. Maybe we can move on to the next slide. Next slide.
What I suggest, what I suggest here,
We were the last.
yeah. So this is the last. I think this would
Dr.
be
Lipika would be taking, and I think Dr. Raghuram has already covered most of the points here. So with this, and as far as the foreign obligation is concerned, like, the US is not part of CBD, and as far as Europe is concerned and other major jurisdictions, the mostly what can be done is to ensure that what is the source and geographical origin of your biological resource at the moment. That is something one can, take care of. Because in any case, you now have to submit a declaration if you are using a foreign material. But as of now, that should be the obligation that one needs to do. So maybe we can move on to the next slide. We have come to an end to our presentation.
this is general.
Yeah.
This is general.
So
Shows about our participation at different forums and how we are involved in the policy decision making. But with this, we can conclude, and I think we are giving stage back to you, Bharat. Thank you so much.
thank you.
Yeah. Thank you, Dr. Dutt and Dr. Kalra. I will let you please hang on with us because we will like you to take some question and answer. We have one more speaker. So let
Sure.
Lipika give her talk and we'll have a question and answer.
I'm sharing my presentation.
Has been working in IPU for last more than a decade almost now. And before that, she was working in patent office for more than a decade. And the floor is yours, Lipika. You can just.
Yeah, thank you, ma'am. I am trying to share my presentation. Is my screen visible? I think it is the previous presentation that is being shared.
Just unshare, Deepika, unshare once and then share your screen.
Okay, what I'll do is
Unshare and close Dr. Ranjana's presentation. And then share your.
yeah. Ma'am, is my presentation visible now? Yeah, is it in slide?
Yeah, Dr. Lipika, we can see.
So quite a part of my presentation has already been covered. So to start with, I must say we all understand the requirement of biological diversity and its conservation of biological diversity and its sustainable use. And the important part the Act, rules and regulation play in such process. In this session, we'll be basically covering the amendment in the rules and forms that are required for different activities, their corresponding substantive law and procedural law. Initially, I'll focus on the definition section provided in the Act and basically the rules, and basically amendments, forms related thereto, basically covered under section 3 to 7. So before proceeding, I would like to focus on 3 major events that has happened in the last few years. The Biological Diversity Act 2002 has been.
Lipika,
Yeah,
Lipika, I think You can skip whatever has already been said, and let's come to the crux of your talk today. Okay.
Right.
You can
right,
skip
right.
whatever has been already spoken about by Dr. Raghuram and Dr. Kalra. Okay.
Right, ma'am.
Go ahead.
Okay.
Please go
So,
ahead.
yes. These are the major events which has already been talked about, but it is going to influence the regulation of biodiversity in India in the coming years. Access, codified traditional knowledge, derivatives has these terms are already been defined. I would like to mention that access was there in the Principal Act, but now it has been added. It has been defined in this particular amendment. Codified traditional knowledge basically refers to those traditional, refers to the first schedule of the Drug and Cosmetic Act. It is basically a list of books where based on traditional knowledge, and if anything that is derived from this books, it will be considered as codified traditional knowledge. Derivative has already been defined. I'll not be coming to that. Coming to biological resources, derivative is included in this term, which has already been discussed. Biosurvey has been delinked from bioutilization. In the Principal Act, it was being used simultaneously everywhere, but biosurvey is construed as something that is happening in the field, and bioutilization is construed as something that is happening in the laboratory. So it has been delinked and defined. The terms defined in the rules, basically, Act means Biological Diversity Act 2002, adjudicating officer has already been defined. Fee means fee provided in the first schedule of the rules. Forms means forms provided in the second schedule of the rules. Okay, now moving forward to the substantive provisions. These are already covered. Actually, this session was intended to only focus on the forms related to IPR. But here I want to mention that CSI, being an R&D organization, is being involved with different foreign bodies as well for collaborative and some sponsored research. So liability of these foreign persons are to be understood, and our liability when we are in collaboration with them is also required to be understood. So section 3% and 3.2% and who are they are already covered in the previous presentation. Coming to the rules part, basically coming to the procedural part, where this section 3.2% is applying for IPR, applying for access of biological resource for research, biosurvey, and bioutilization. Form 1 is required to be filed. When he is applying for commercial utilization, Form 2 is required to be filed. There is an element of retrospectivity. It means any person who is in possession of a biological resource before the commencement of the Act has to abide by the Act. Fee is to be paid by electronic or digital format. Processing time is 90 days. In case any, like in this process, once this application is filed, the NBA will be in consultation with BMCs, and they will collect additional information. And if it is okay, then the permission is granted in 90 days. And in case any information is sought from the applicant, which is not replied within 30 days, then the application will be considered closed. And BMCs may consult with the individual communities, as already discussed with by Dr. Raghuram, for obtaining their prior informed consent. And in emergency situation, NBA has to expedite the process. Grant, as we have already discussed in the previous presentation, it has to be by way of an agreement on mutually agreed terms. So basically, we call it ABS agreement. ABS agreement is to be signed by the applicant. In case it is not signed within 60 days, then the application will be considered closed, and it could be divided by payment of half the amount of the initial filing fee within 90 days, 90 days of its closure. And coming to rejection, if it has to be rejected, rejection has to be in writing after giving the applicant an opportunity of being heard in natural justice. And whatever is being granted or rejected has to be published by NBA. So in this process, I have mentioned about two different forms. Form 1 and Form 2. Coming to the purpose of this form, Form 1 is for prior approval by Section 32% for research, biosurvey, bioutilization. Fee is 10,000 and 20,000, individual and entity respectively. Form 2 is basically for accessing biological resource for commercial utilization. Fee is 10,000, 20,000, individual and entity respectively. Now let me go to the forms and see what are the important components of the form. So basically, the particulars of the applicant is to be provided. Details of the biological resource, associated traditional knowledge thereto is to be provided. This is for research permission. So expected duration of research, type and extent of research, institution where the research is to be conducted, mode of benefit sharing, benefit that could flow to India from this activity, any other information, and fee remittance information is to be provided. So coming to Form 2. Form 2 is required for commercial utilization by Section 32%. So Form 2 details which are required on Form 2 are details of the particular of the applicant, details of the biological resource associated or knowledge associated thereto, then purpose of it is for commercial utilization, so type and extent of commercial utilization, then approval in case approval taken for access, because commercial utilization comes a step ahead after the access to biological resource for, so details of the approval obtained for access of biological resource, and for research and biosurvey and all, mode of benefit sharing, and the what is the benefit that may accrue to India or Indian community in for this activity, any other information, and fee remittance information is required to be provided. So basically, a few components of Form 1 and Form 2 are same, but I would also like to focus on those components which are specific to Form 1 and specific to Form 2. So Form 2 is for prior approval for research. So the duration of research, type and extent of research, details of the institution where the research is to be conducted is to be provided. And in Form 2, which is for commercial utilization, type and extent of commercial utilization, and because commercial utilization comes ahead after access permission for research, biosurvey or bioutilization, then details of that approval is also required to be provided. Now let me move to Section 4, which basically says that transfer of result of research is not to be done to a 32% without prior approval. It says that no person shall share or transfer the result of research on a biological resource occurring in India, obtained from India, access from India. This is the term defined as a newly added term in the definition, or traditional knowledge associated thereto for monetary consideration or otherwise to a 32%. So and without prior written approval of NBA, and codified traditional knowledge is exempted here. So here I would like to mention that there are some provisions in this section as well. So it says that this section shall not apply to transfer of result of research which is happening for publication in research papers or dissemination of knowledge in seminar, workshops, if it abide by the central government guidelines. And it further says that if the transfer of result of research is for further research, registration with NBA is required, and if the transfer of result of research is for commercial utilization or for IPR, then prior approval is required. So it was required to talk about this section because everything is connected to the forms. Now coming to the procedural part, which is provided in Rule 15. Coming to application process, when there is a transfer of result of research to a 32%, first and foremost, the transferor has to file or has to take prior approval of NBA on Form 3. If there is transfer of result of research for further research by the transferee, then Form 4 is required to be filed for registration. If there is a transfer of result of research for commercial utilization by the transferee, then Form 5 is to be filed by the transferee for prior approval of NBA. If the transfer of result of research is for obtaining IPR by the transferee, then the transfer of result of the NBA prior approval is to be sought by the transferee on Form 6. Here, I want to mention a particular point. CSIR has been involved in the Amendment of Biological Diversity Act, Amendment of Biological Diversity Rules and Regulations as well. And head IPO has been a member of the working group and presently ex officio member of NBA as well. So we have been through the amendment and the stages and the initial drafts. So in the initial draft of these forms, it was not very clear that who is going to file which form in what circumstances. And we have provided our input. It was taken into consideration and by the ministry. And now it is quite clear that who is going to file which form at what point of time. Okay, now let me get back to the process. Fee is to be by electronic or digital format. Processing time is 90 days. And in case any information is sought from the applicant, which is not provided within 30 days, then the application will be considered closed. And in case the application is being rejected, applicant must be given an opportunity of being heard on because of the natural justice phenomenon. And in case and about the granting is by way of ABS agreement or mutually agreed on mutually agreed terms, other than this registration on Form 4. Here it is, when I'm saying registration, it is only the person has to apply for registration. When I'm saying NBA approval, it means an NBA approval by way of ABS is to be obtained. And in case the grant is provided, which is not signed by the applicant or the ABS agreement is not signed by the applicant within 60 days, then the application will be considered closed, which could be revived by payment of half the amount of fee within 90 days. And in case the transfer of result of research is contrary to the the objectives of our act, or it is detrimental to the objective of our act, then NBA may prohibit or restrict. And in case the registration is obtained for further research, then NBA is to be periodically updated. Okay, in between, I have spoken about 4 forms, 3, 4, 5, and 6. So Form 3 is basically for commercial purpose or otherwise, and it has to be sought by it has to be sought by the transferor. And so the fee for individual is 5,000, for entity it is 10,000. And Form 4 is for further research by the transferee. So it has to be filed by the transferee for prior registration with NBA. Fee is 2,000 and 5,000 individual and entity respectively. Form 5 is for commercial utilization by the transferee. So prior approval by the transferee is to be sought on Form 5, and fee is 10,000 and 20,000 respectively for individual and entity. And Form 6 is for prior approval for filing IPR by the transferee. So the fee is 5,000 and 10,000 for individual and entity respectively. Now let me go into the details of this form. So details of Form 3, which is to be filled by the transferor. The transferor may be an Indian entity or a foreign entity as well. So if it is being filled by the transferor, the details of the applicant is required. Then details of the result of research which is being transferred is required, the biological resource or knowledge associated thereto. Then details of the approval obtained by the 3-2 person. In case the transferor is a 3-2 person, then he must have obtained prior access approval. So that is the information regarding that is to be provided, and details of the institution where the research is done, that is to be mentioned. Whom it is to be being transferred, that is to be the transferee details are to be provided. And further, what is the benefit that will accrue to the applicant, that is also required to be provided. The agreement or MOU between the transferor and the transferee, that is also required to be provided. And any further information and remittance information is also required to be provided. So these are the details required on Form 3. Coming to Form 4. Details of the particular of the Form 4 is for further research by the transferee. So the applicant here is the transferee, and particulars of the transferee. Then approval obtained by the transferor, that is also required to be provided. Details of the research activity.
Lipika?
Yeah, ma'am.
Deepika, can you summarize and go ahead faster? We are towards closing. We have to take question and answers also.
Okay, ma'am. Okay. So in this case, this particular form is for further research, so expected duration of research, outcome of research, benefit that may flow to India, and other informations are required. Form 5 is for commercial utilization. So here, rather than going back to that form, I would like to mention about those specific part of the forms that is required for that specific part, specific form. That is, this Form 5 is for prior approval for commercial utilization by the transferee. So the description of the commercial utilization and expected duration of the commercial utilization are the important part of this form. Other informations are basically common to other forms as well. Coming to Form 6, which is for filing IPR by the transferee. So details of the transferor, details of the approval obtained by the transferor, and the details of the invention are the important part of this particular Form 6. Section 5, I think it has been covered by others, but it is basically an exemption clause. It says that collaborative research between government-sponsored institution in India and similar institution in other countries. In that case, provision of Section 3 will not apply if it abide by the policy guidelines of central government or it is approved by the central government. This is a substantive law. There is no corresponding procedural law for it. Now, the most important part of this session, that is IPR. Section 6 basically says that IPR is not to be obtained or without prior approval of NBA. There are 3 components in this section. First component addresses obtaining IPR by 3-2%. Second component addresses obtaining IPR by Section 7, which means Indian entities. It has already been discussed in the previous presentations. And the third part of this also refers to Section 7% when the IPR is being commercialized. So basically, Section 6(1) says that in case the 3-2% is filing for IPR in or outside India for invention which is based on research or information on a biological resource accessed from India, or that is deposited in a repository outside India, that will also be considered, and traditional knowledge associated thereto, then prior approval of NBA is required to be sought. When it is a Section 7 person or an Indian entity who is filing for IPR, in that case, they need to register with NBA. And in case this Section 7 person is commercializing the IPR for which he has already sought for registration, then in that case, prior approval is required. Coming to the procedural part, there are 3 components in the procedural part. Basically, Section 3 person applying for IPR has to apply on Form 7, and fee has to be paid by electronic or digital format. Processing time is 180 days. Application will be considered closed if the information is sought from the applicant and not provided within 90 days. Grant is by way of ABS agreement, and it could be, if not signed by the applicant within 90 days, application will be considered closed, which could be revived by payment of half the amount of the initial filing fee. So, and grant is to be informed to NBA within 45 days. So here there is an important thing, that is digital sequence information. So I'll come to this in my last slide, I think. The second part of this rule is for Section 7 person who is applying for IPR. So he has to register with NBA on Form 8. In case the information is illegally obtained, the NBA may impose penalty. Grant of the IPR is to be intimated to NBA within 45 days, and the applicant has to undertake that he will be seeking approval of NBA at the time of commercialization. And the third part is for the process before commercialization. Application has to be sought on Form 9. Approval has to be sought on Form 9. Fee is to be provided by digital or electronic format. 180 days is the processing time. Grant is by mutually agreed ABS agreement. In case the application is not, in case it is not executed by the applicant within 90 days, application will be considered closed, which could be revived by payment of half the amount of the initial filing fee. These are the process for when it comes to IPR. Here there are 3 forms discussed. Form 7 is for prior approval obtained by 3-2% for filing IPR. Fee is 5,000 and 10,000 for individual and entity respectively. Form 8 is for registration by Indian entity for IPR. Fee is 2,000 and 5,000 for individual and entity respectively. And Form 9 is for prior approval for filing IPR by Section 7, for commercialization of IPR by Section 7%, and fee is 5,000 and 10,000 respectively for individual and entity. Now, I will not go into the form, just to mention what are the important part of this form. Form 4 is for approval for IPR by Section 3(2)(%. So details of the approval obtained for access of biological resources to be provided, and the organization where the R&D is done is to be provided. Form 8 is for registration for Indian entity who is before the grant of the IPR. Then details of the information, details of the biological resource or knowledge associated thereto, and organization where the research is done is to be provided. This form is basically, yeah, ma'am.
Please go to your last slide, and yeah, just go to your last slide.
I have 2 slides more. So
no, last slide, please. We have reached the time limit. Yeah.
So I will be skipping Section 7. Section 7 basically exempts, it's those person who will be accessing biological, the Indian entity who is accessing biological resource for commercial utilization has to intimate to State Biodiversity Board. Exemptions are already provided by the previous speakers. And it has to be applied in case it is a codified traditional law, it is a cultivated medicinal plant, then certificate of origin is to be obtained from the BMC on Form 11. Form 10 and 13, I think it has already been covered by the previous speakers. And 40 is also covered by the previous speakers, which is now expanded from the principal law. Last slide is for the ABS guidelines, the access to biological resource and knowledge associated thereto, and fair and equitable sharing of benefit regulation 2025. Only the major points, it supersedes the ABS regulation 2014. Here, the digital sequence information is included in every part of the provision. The important point is that in the Cali conference, that is in COP 16, right, ma'am?
I don't know whether it is working. This is covered by Raghuram, so I think we can skip it. You just thank and we'll take question and answer.
Okay,
all these point 2, point 4, and point 6.
Okay,
yeah, this has been covered. Yeah. So we'll take some question and answers. Now, if there are any questions.
Yeah, am I audible,
Raghuram,
madam?
And
yes,
you are audible.
Yeah,
Go ahead and take
Yeah, thank you, madam. I have a small specific 2 questions actually to experts from NBA or anybody. In that thing actually, earlier last year when draft rule came, at that time it was proposed that for non-commercial means whatever for filing patents, which includes that biological material, at the time of filing we will not require to take the NBA approval unless it goes for licensing or commercialization. At the time of licensing or commercialization only we will have to take the approval. But I think later on when the draft came as final rule, that time that thing was removed. So is it not means cumbersome for R&D institutions for this kind of clause that if it make it mandatory, if it is not commercial, it is not leading for a commercialization, and any patent which involving biological material, we are going for NBA approval. So it is a difficulty for us also, as well as NBA also, to dealing all these things. So Dr. Raghuram can, I think, speak on this.
Thank you, sir, for your queries. At the time of we are repeating, for obtaining a patent, you can access the biological resources conduct a research over it, which may culminate in the form of an IPR. You may go for filing IPR in the patent office in or outside India. Before obtaining the patent, before grant of patent, you have to simply register with the NBA. For you as a CSIR scientist, the cost is around 2,000 only. That is what form number 8, our previous speakers also said, for individual, for registration 2,000, for individual 2,000 rupees only. But if you are filing in the name of CSIR, then it will be 5,000 for entities. There is no question, there is no agreement, nothing. Only you have to register with the NBA. After registration, within 10 days, you will get a certificate, or I can say it is a registration form. So, 1 second. That is the only requirement. I'm telling at the time of commercialization, after you obtain the patent, if you find out some company and pass on this rights to the company, before that only you have to take an approval. Till that time, you have to only do registration, for which you have to pay 2,000. Any more clarification required, sir?
Okay, okay. That means we need not to file Form 3 in that case. Form 3, if it is not leading to commercialization.
Sir, Form 3 is now ruled out. Form 3 after December 21st December 2024 onwards, Form 3 is no more. For Indian, for obtaining IPR, you have to replace the Form 3 into Form 8. Form 3 into Form 8 and 2,000, or if you are normally Dr. Shrikar Rastogi, Madam Dal sitting there, you will file in the name of CSIR. In that case, you have to pay as a registration fee 5,000. By this time also, you might have Madam Banu Verma or Shika Madam can throw light on that. They would have got the registration.
Okay, okay.
Yeah, Sanjeev, to make it simple in one line, now for NBA permission, please proceed to file Form 8 with a fees of 5,000. That's all.
Okay, 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 madam. Yeah.
Madam, can I add some point here? Wherever it is written that prior approval of NBA is required, that should lead to a ABS agreement. Wherever it is written that registration with NBA is required, that no ABS agreement is to be obtained. And the patent application will be granted without a ABS agreement. You have to enter into a ABS agreement. You have to apply for a prior approval, and you have to enter into a ABS agreement when your IP is being commercialized.
Okay, okay. Then it is good. Yeah. Okay, madam. Thank you.
The questions?
Hello.
Where biological resources have been used in the invention, then yeah. Who is,
I have a small query from Raghu sir.
Yeah,
So you discussed
identify
regarding, myself, Dr. Upendra from ISVT Palampur.
yeah.
So my query is regarding, you discussed with respect to the issuing a certificate for the cultivation status of any medicinal plant. So is this database or something that how many medicinal plants are cultivated, or what is the status? Is it available anywhere, or from where we can get this?
Thank you, sir, for your kind information. The nodal ministry is the Ministry of Ayush. So the Ministry of Ayush, they have forwarded the list of cultivated medicinal plant species in India. They have forwarded the list. Of course, the list is not a comprehensive one. It has to be further refined. But area-wise information may not be available right now. Cultivated medicinal plants are available. You know, last 10 years, 10-15 years, the Ministry of Ayush has given subsidy to the farmers for cultivating so many threatened species and other things. In the chat box itself, I have mentioned, Dr. Ranjana raised this point, how this certificate will be issued. Will it take time for the BMC to issue and all? We said very clearly, we are developing a software. That software, the moment he uploaded the information, the applicant filed the application, the software will speak to the available data and generate the data and give the certificate. There is no question of taking time here, auto-generated information. Thank you, sir.
Thank you. Thank you, sir. Thank you.
I have a question to Dr. Raghuram.
Yeah, Indrani, you can go ahead.
Yeah. This is Indrani Ghosh from IPO itself. Dr. Raghuram, I wanted to ask whether what will be the format to submit the digital sequence that you mentioned?
Ma'am, with regard to the digital sequence information, you no need to submit to the National Biodiversity Authority. For example, in the case of if you want to access the digital sequence information from the American Culture Collection or NCBI or in the Korean center, there are about 3-4 major centers are there, DSM, ZI, all from Germany. When you are accessing an Indian material, for example, you are an Indian, you can access the material, use it for research. It's all free, no approval is required. Whereas if you are a foreigner and you want to access that material and use it for research, then in that case, prior approval of National Biodiversity Authorities must. You have to apply in Form 1. Accessing the material from repositories, this thing. You may raise another query that, sir, I want to submit my DSA information in the foreign repositories. What is the procedure for that? For which and all you have to follow the transfer of research result application form. You can do it. Okay. That is section 7 will attract those provisions. Those things and all.
Yeah, so we don't need to submit the DSI to NBA for prior approval if we are proceeding with commercialization.
No, ma'am. No, not required. See, nowadays the DSA information and all, it is fully catalogued. Only that sequence number and other things is enough for us. How do we know? NBA is not having that capacity to check how many base pairs, all those things are all technical jargons. We want only this catalog number from so and so repository. That if you are using it in your invention, that is more than sufficient. We will not ask that in case in future, if such requirement is there, that will be provided in our FAQs and guidelines. As of now, using the DSI alone, regulating under the Act.
Okay, thank you so much. Thank you.
Dr. Baleshwar, you can go ahead. Ask your question.
Hello.
Unmute yourself.
My question is with Dr. Raghu. Dr. Raghu, I just want to apprise myself that there are a number of records, PDRs have been developed in South Indian states. Okay, and work is going good. But in northern states, it's not so good. Is a biodiversity authority is taking some decision or making some extra efforts?
Thank you, sir, for your kind information. 7th August 2017, the Honorable Court, the National Green Tribunal, ordered that all BMC should be constituted across the country if it is not done. So, and another thing is PBR has to be prepared, as well as that PBR quality also to be checked. That responsibilities they have fixed on the Ministry of Environment and Forest, National Biodiversity Authority, State Biodiversity Board, as well as they served the notice to the Ministry of Department of Rural Development of all states. Comes under the Ministry of Panchayat Raj and Rural Development. Now it is a 2 different ministry. So accordingly, as on date, as per the court order, all these things, 2,68,000 something PBRs are ready. For example, sir is pointing out the Northeast and all. I'm telling you, if you can type it in the Google itself now itself, biomiss, you put biomiss, biodiversity management information system. If you go into that, it will show you Tripura, Assam, Goa, Tamil Nadu. So these are all the states have provided the inputs in the electronic format. Rest all they have developed. There are about 12 states have been selected as a pilot states, and last 1 year we are working with them and adding the inputs. Very shortly we will come out with those information. But even now also for Tamil Nadu, Tripura, Assam, Goa, those informations are available to the public, including the biological resource name, occurrence, area of species, all those things. You can see it in the form of a PDF or searchable mode is also available. The software name is BioMiss. Still it is under the beta version. Thank you, sir.
Dr. Prabhu, my concern was with the northern states like Uttar Pradesh, Haryana, Rajasthan, Punjab. Because these are the
Dr. Baleshwar, can you just limit your questions? We have more questions. You can interact one-to-one with Dr. Raghuram later. Dr. Dharam Singh, you have a question, please ask.
Yes, ma'am. So my question is, like if a patent is filed on the bioresource acquired from the foreign, so what is the rule in NBA in that case?
Sir, I couldn't get your point clearly. Bioresource from where? India or outside India?
No, from the outside, from the foreign.
Whether that biological resource belongs to India or outside a foreign bioresource?
For example, like hing, hing was actually brought by ISPT from the Iran and Afghanistan, and now a patent from ISPT using the callus culture is filed. So what is the rule in this case of NBA?
Sir, slightly your voice is not clear, but I will tell you one thing. If you are accessing a material from Afghanistan, Iran or somewhere else, and that material is not belongs to India, it's purely from Afghanistan or Iran, no approval is required from NDA. Why? Because the act is very clear that the biological resources occurring in India, so obtained from India, it should be belongs to Indian material, not that foreign material. So foreign material, no approval is required. You know well that the patent application itself, it is very clearly mentioned. If you are using an Indian biological material, then only competent authority approval you are supposed to submit. Otherwise, you are free to do so. Our approval is not required. I hope I clarified.
Yeah, so Dr. Shiv Pandey.
Yes, I am Dr. Shiv Pandey from CSR IIT Kuala Lumpur. I have one query for Dr. Raghuram sir. Actually, we are working on the microbes and we are developing a formulation of microbial resources, microbes, and we are going for patent for this formulation. So for this, we should submit these, we should deposit these microbes to any internationally recognized depository before patent application, or after patent application, we will submit these microbes to the any depository.
Sir, for patent as concerned, for patent matters are all concerned, I'm telling you two things are there. Under Budapest Treaty, any novel strain under the Budapest Treaty, you supposed to submit in the IDA, International Designated Repository, something they are telling. What in India itself, your CSIR Pune lab as well as NCL Pune and Chandigarh IMTech is are all internationally recognized repositories. There you have to submit, then only patent will be given to you. That is for patent. NBA's BD Act is not at all coming into the picture at all. Yeah. We are talking about only patent. At the time of patent, at the time of commercialization, you need not deposit any biological resources under the BD Act. Only if you are accessing it for commercial purpose. If you yourself accessing will occur or not, I do not know, because you will give it to the company. Company people will access it. By the time they have to go to the SBB or NBA, then they have to submit the microorganism. Otherwise, for obtaining a patent, you need not submit any samples in the repositories. This is our clear stand. I hope I clarified you clearly.
Actually, we should submit in IDA, means like MTCC, before patent application. Is it?
Sir,
Let me interrupt Dr. Raghuram. For filing an Indian patent application, before filing a provisional application, you have
Actually, ma'am, your voice is not getting
Patent
here.
Act.
Yes.
You can hear me now?
Yes, ma'am. Please repeat again, ma'am.
So there are 3 repositories which have been authorized by Indian Patent Act and which are authorized for patent filing in India.
Ma'am, your voice is gone.
Ma'am, your voice is not coming.
Yeah, just now you can hear me?
Yes.
Yeah, so before filing a provisional application, you have to get the depository details. Okay, so patent filing, for patent application filing for microbes, you have to have deposition details either in Indian repository which has been recognized by patent office. There are yes, or international repositories if you are able to, but Indian repositories are good enough. But you have to deposit before filing even a provisional application. This is not requirement of Biodiversity Act. This is the requirement of Indian Patent Act. Okay.
So deposition will be patent deposition or general deposition?
No, microbe deposition in the repository. You were asking about microbial report.
There are two categories for
Repository.
There are 2 categories for microbial deposition. One is the general deposition, and another is the patent deposition. So, in which category we will deposit our microbe?
In patent related repository.
Patent purpose.
For patent purpose.
But it will cost almost 20,000 for each microbe. Suppose later our patent was not granted. So why we will give for patent?
That is not besides the matter. The matter is you cannot file a patent application unless and until you have a depository detail. Okay.
Okay.
So you have not an issue. The issue is a requirement of the act. You have to fulfill the obligation of act if you are wanting to get a patent.
Okay. Thank you, ma'am.
कैसे काम करता है? Any other questions from the audience? If there are no further questions, I think I'll propose a vote of thanks and it has been my pleasant privilege to organize this program on International Biodiversity Day 2025 today. And the invited speakers, Dr. Sanjay Kumar, and Dr. Ranjana, and Dr. Kalra, and Dr. Raghuram and Lapika have done an excellent job in throwing light on the aspects of Biodiversity Act, Biodiversity Rules, 2023-24, and the requirements thereof for filing patent applications in India and for commercializing or at the time of technology transfer of these applications which have been filed, patent application which have been filed. So I would like to thank, first of all, Dr. Sanjay Kumar, Chairman ASRB, ex-director CSIR in IHPT, Palampur, for giving the keynote talk and speaking on the issues and sustainable use of sustainable use of biological resources. He's talked extensively on use of biological resources. and focus on sustainable development goals, monitoring the implementation of issues regarding biodiversity matters. Secondly, Dr. Raghuram spoke extensively on requirements of new act and new.
You're not audible.
Dr. Ranjana, yeah, there is some issues, I think, from our end in the mic system here. So I hope now I am audible. So on the issues regarding Dr. Ranjana and Dr. Kalra from Remfree and Saga talked upon new act and new rules. Further, Lipika threw extensive light on the forms and formats and the fee structure which are required for seeking permission for biodiversity related matters for applications where biological resources from India have been used. Dr. Lipika, Dr. Kalra, for taking your precious time out and throwing light on the issues regarding biological resources and Biological Diversity Act and rules. Further, I would like to thank all the attendees who have taken their time out and the IT division of CSIR headquarters who have posted the flyers of the program on the CSIR website, and the SCTD team for live display of the program on the YouTube and Facebook channels. Lastly, I would fail in my duty if I do not thank my head, CSIR IPU, for
It's good we can't hear you, Bhanu. Thank you.
Yeah. Yeah.
So you don't need
for
to
participating.
thank me. Yeah.
And the team IPU for being, as usual, giving participation to this program. Thank you so much.
Thank you all so much, and apologies for any I mean Bhanu's mic going off at most inopportune moments. There is some problem with our system there, which we are getting rectified. But thank you all, and thank you to all those who have remained here with us, at least 41 audiences who've been with us through this particular very important session on biodiversity. And thank you from NBA as well as Dr. Ranjana. I don't see Dr. Sanjay Kumar, but thanks to him also. And